husky. Good morning, it's another day, my friend. But soon the sunshine turns to moonlight, life goes on. It takes some time to say goodnight, you close your eyes to dream next thing tomorrow's here. It's a brand new day, never hold on to hate. Cause you was placed here to be great. Please take your place. All queens got a seat at my table. Cause without y'all, then the man ain't able. Melanated queen, connected to the universe. And so I gotta thank my mom for my birth. If hate is the curse, then love is the remedy. So I send you love no matter creed or identity. Until infinity, look at you like you kin to me. Even when we disagree, yo, you still kin to me. In other words, I can't bring you no trouble, can't bring you no beef, don't wanna see you deceased. Now if I'm coming at you, I'm coming with a business plan. Cause every day I'm on some, yo, let's get this money, man. Yeah, and that's my real plans. I rest my head at night, I wake up, I got another plan. Good morning, it's another day, my friend. But soon the sunshine turns to moonlight, life goes on. Tell me why we don't get money together, but we'll kill each other over whatever. Running down the freeway, we gonna own down. If Black Lives Matter, why we gonna own down? That's why they laugh and they think that we clowns. They hear what we say, but see how we get down. We gotta change that now, right now to be exact. Cause hurting that man's moms is not where it's at now. Old school, new school, need to learn, yo. They put us in groups so they can make more dough. The young versus the old versus the young. Black versus white, you see the pattern, right? No unity, keep them all on some gutter-ish. This way they don't prosper and get rich. Yo, can't you see it's a trick? Open your third eye and you'll see the full view of it. Now yo, what if the powers that be know that the real power lies within the people? That's us. And what if they using things like crayon colors, black and white, to separate the people? Hey, yo, you gotta wake up. Don't let them fool y'all. Spread love. Good morning, it's another day, my friend. But soon the sunshine turns to moonlight, life goes on. It takes some time to say goodnight. You close your eyes to dream next thing tomorrow. Good morning, it's another day, my friend. But soon the sunshine turns to moonlight, life goes on. It takes some time to say goodnight. You close your eyes to dream next thing tomorrow's here again. Good morning, good morning, good morning, good morning. Good morning, good morning, good morning, good morning. Good morning, good morning, good morning, good morning.
Of course, I did all that talking and y'all couldn't hear me. Now you can. Drop a 1 in the chat if you can hear me, and drop a 1 in the chat if you can see me. Let me know how y'all are feeling on this Monday morning. We're gonna get it together. Welcome, y'all. Welcome back to another YouTube live stream and another episode of the Music Morning Show. I'm your host, ClassE Beats of ClassEbeats.com. Today we are getting back into more of this YSL trial. We've got something interesting today. It looks like we're actually going to hear some testimony against Young Thug himself. I know. It's finally gonna happen. We're finally gonna hear Young Thug's name mentioned for the first time in this entire trial. So y'all get ready for it. I'm not gonna waste any more time though. Let me say what's up to the people and then we'll get right into the coverage. Amy is in the building. Shout out to the amazing, awesome Amy is in here, showing up every single show and doing some work. I appreciate you, Amy. Thank you for everything that you do here. Shout out to Landis Mobile is in the building. My guy Mark is up in here. Z is in the building. We've got Satin, Andrea, Nicholas is in here. Nicholas. I gotta say it right. Drama Llama's in the building. That's a dope name. Michelle, we've got A Fritz, Tanya, Justin, Yellowbug is in here. Kristen's in the building. Good to see you. We've got Jay Buckmaster is in the building. Anita, good morning and salute. Thank you for your service, sir. To John up in here as well. D is in the building. The World's End. Randall King, my guy. Good to see you as always. Nicole is up in here. Michi back in the building. The Honorable Attorney Kel Bell is the building as well. Thank you to all our amazing attorneys, our resident attorneys here who watch the show and give some great insight and feedback. Kel Bell is one of those, and I appreciate you. Tunnel Vision's in the building. We've got, who else is in here? Michelle Corley is in the building too. Good morning, Michelle. We've got Naya Dore. We've got S. Dot from Detroit. What up, though? Shout out to Detroit in the building. Speaking of Detroit, my guy, Anton Daniels, Mr. Detroit, stopped by the show on Friday, and I completely missed his comment. I was so hurt. I had to go over to his other live stream and say what's up. But shout out to my guy, Anton Daniels, stopping by the show on Friday night. I appreciate you, man. And shout out to Detroit. We got Sammy up in here. Good to see you, Sammy. Phenomenal RN is in the building. And then I know we've got a bunch more of y'all in here. I'll be saying good morning to y'all throughout the show, so make sure that you say what's up in the chat so I can say good morning to you. Shout out to Granny Mo is in the building saying good morning and has been a member for 1 month. Thank you, Granny. I appreciate you being here in the building. All right, if y'all could do me one more favor, make sure you like the video on your way in. Not only is it free, but it does help the channel continue to grow, and it lets the YouTube algorithm know that y'all are enjoying the show, and it shares it with more people. All right, let's go ahead and get into this coverage. I'll be saying what's up to a couple of y'all here in the chat shortly, but let's go ahead and see what's going on in this YSL trial. Dang, it looks like Law and Crime is a little bit frozen over there. That's weird. Hold on a second. I think their camera feed was probably frozen, y'all. Let me skip ahead a little bit. There we go.
Mr. Lamar, they have already essentially, I mean,
and I'll get the sound right for y'all too. The sound was super low this morning.
Can we make sure that we follow 24/7 704, which we will? But in terms of preventing testimony short of something that would violate that statute, it's denied short of that. So it's, you know, it's not going to change any of the previous rulings about what various experts can testify to. All right, motion in limine 65.
So we got a couple motions we're reviewing that were filed over the weekend. We might go over those later. We have Miss Love taking shots at Brian Steele.
Let me look at the response again real fast. I didn't.
Doug Weinstein's not in court today. We have this
with me this morning. So
this fine gentleman here.
Actually, I think they're arriving right now.
We got Yak Gotti in there with the fresh 70s suit. I like it.
So the contours of Investigator Viverito's permissible testimony have already been established as well. And so we won't be changing the ruling on that either. And then we've got
Mr. Matthews over there.
motion limine 66.
Yeah, Yak. I keep saying Yak has the best drip out of all the YSL defendants.
Concerns Mr. Lamar, Rich Homie Kwan, and neither side really should be able to say It seems that the defense wants to bar the state from being able to say, the defense didn't call this witness at trial, which obviously they concede they have no right to do and say they have no intention of doing, and they would not be permitted to do such. But at the kind of flip side of the same coin, the defense seems to maybe be suggesting that they would like to present that the state could have but did not call that witness. And I would not permit that either, because we're clearly nowhere near, unfortunately, the end of the state's case. And obviously,
nowhere near.
Mr. Lamar has now passed, and so we don't know whether they would have called that witness or not. So I wouldn't permit the defense to make that kind of a presentation either. So I trust that everybody understands what they would not be permitted to do. And then we have, yes, sir.
She said they're nowhere near. Goodness.
Good day, Your Honor, and good day, everyone.
Good morning.
So, I understand your ruling, obviously, abides by it, but what I'd like the record then to show, if you don't find this to be changing, the state sent us lists of witnesses on a short list that they were going to call Mr. Lamar, who's a performer known as Rich Homie Quan.
Rest in peace.
This was well before September 5, 2024, when he, God forbid, passed unexpectedly. So, to me, and the state has put in evidence over objection that starting in the fall of 2014, Mr. Lamar and Jeffrey Williams don't get along, and Mr. Lamar is with Mr. Donovan Thomas, who doesn't get along with Jeffrey Williams. And it's all, to me, it's all made up. It's not supported. Obviously, the jury can make that determination. But I think that it is important that the state, in writing, put the predecessor court, as well as Mr. Williams et al., on notice that they were going to call Mr. Lamar. They filed their service of a subpoena, and they don't call him to support this, supposed beef. And I can't do anything about his prior statements now because it would be frivolous under 24-8-807, which is rarely used. It's frowned upon, and it has to have the same guarantees as a dying declaration or something. It's not like that. He gave interviews throughout all the years talking about his close relationship with Jeffrey Williams. And if you let that in, that's great with me. But I'm assuming you're not going to let it in, so I wasn't going to try to get it in because I don't think that that's a dying declaration type of statement. So I'm stuck. So I would like the jurors to know that unfortunately he passed, and this state stated that they would call him as a witness and subpoenaed him. And if the state has reasons that they didn't call him, that's fine. I understand I'm opening a door, but that's why I put it in writing. That's my motion.
All right. Well, I mean, if the state's case were over with, then that would be a different argument. But it is not as though the state's witness list has stayed in anything like any semblance of order during this trial. So, I mean, I don't think that if you can get a concession out of the state that they weren't going to call him even if he stayed alive, that would also be different. But I don't think that we've got that
I don't think
situation.
they're going to do that, no.
I understand the ruling.
All right.
Thank you, Your Honor.
Okay, and then we have this issue of the state wanting the court to reconsider its ruling.
Oh, here we go.
Striking whatever day that
Detective
was.
Dennis
one day
was on Friday.
The detective's testimony and the defense response. And I believe, and Mr. Armstrong, I see you standing because you might want to argue, but I think that the waiver argument that is presented in the defense response is meritorious. I think that the
Who
argument,
is this? Wait, who did she say this was?
the
Hold on.
waiver standing because you might.
Mr. Armstrong?
I believe, and Mr. Armstrong, I see you standing because you might want to argue, but I think that the waiver argument that is presented in the defense response is meritorious. I think that the arguments that the state made after that they were waived because they certainly were not made at the point in time when I could have done something about it. But in addition, the state last week ended up calling a different detective and investigator, Detective Underwood, who's on the stand essentially right now in the midst of her testimony and seems to be covering the same things that the other investigator was covering anyway. So it doesn't even seem, I mean, it seems like this whole issue is moot.
I think that's Kevin Armstrong, I believe.
May it please the court, Kevin Armstrong for the state.
There he is.
First of all, the contemporaneous objection rule, which was cited by the defense, which is the waiver argument that Your Honor referred to, is one about preserving an issue for appellate review. It is not about a court who can reconsider their rulings during trial. One of the issues that is here is that the court precluded the state from calling that individual back to testify about other things. And that's one of the things that the state filed the motion for reconsideration to avoid. And so the state is asking that for other issues and for whatever issues that have not already been addressed, the state be allowed to recall Detective Dennis to testify about other matters that were not the offending statement, which the court appropriately excluded from evidence.
And if y'all want to know who Kevin Armstrong is, he's the deputy district attorney and the lead. He's the lead attorney over grants. So I messed this up last time. I'm gonna move this over so y'all can actually see it. Meet Kevin Armstrong, a dedicated legal professional serving as the deputy district attorney for our appeals unit. Additionally, he serves as the lead attorney overseeing the crucial Matthew Shepard and James Byrd hate crimes grant, which was entrusted with our office by the U.S. Department of Justice, Bureau of Justice Assistance. Kevin's educational foundation was laid at the University of Georgia. Okay, we don't care about that. Value member of our team since 2015. Wow. Kevin brings extensive experience to the table. Before joining our office, he spent 6.5 years as an appellate public defender in the Doherty Judicial Circuit, showcasing his commitment to justice and defending the right of the accused. As an active member of the legal community, Kevin is affiliated with the Stonewall Bar Association and serves as board member of the criminal law section of the Atlanta Bar Association. Interesting. He firmly believes in the significance of combating motivated crimes, recognizing that such acts not only impact individuals, but also target entire communities. Through his unwavering dedication and expertise, Kevin Armstrong plays a vital role in advancing justice and safeguarding our communities. Y'all give it up for Kevin Armstrong in the building. All right, let's get back to the trial. We know who he is now.
And one of the things the defense brought up in their response was confrontation. I want to make it absolutely clear that there was no intention in the motion for reconsideration to have state's evidence in that they didn't get the right to confront. And so that was not part of the issue. But the issue isn't only the testimony that was struck from that day, it was his future testimony, precluding him from testifying in the future. And while there are other means to get in some of the testimony, I don't believe that is all the testimony that the prosecution team intends to get in through Detective Dennis.
What's up, Javi?
And so essentially it's an ongoing order of the court that we would be asking the court to authorize the state to present that witness to testify further.
So tell me what it is that this other investigator or detective is not going to be testifying to, because she was qualified to be able to testify to the meaning, or her opinion as to the meaning of particular lyrics. So what is it that only this other witness, Dennis, could testify to?
I'm going to turn that over to the facts prosecutor.
All right.
They're still fighting this fight, trying to get Dennis back there.
Thank you, Your Honor. Detective Dennis testified to a statement regarding Defendant Kendrick, in which Investigator Underwood was not present for that interview, and so he testified to that. He also testified further regarding the Quindarius Zachary interview, in which Investigator Underwood was not privy to that interview as well. Additionally, Your Honor, he was able to introduce several additional exhibits to include the Magic City video that will not be able to come in through Investigator Underwood. And I believe those are the three primary things that Investigator Dennis was able to testify to previously that was struck that Investigator Underwood would not be able to introduce during her testimony. In course indulgence for one moment.
So basically what they're saying
Right.
is...
And so what we have ultimately is that there is no evidence, none.
So they're saying the fight at Magic City. I mean, we've had other people testify to that, but they're saying can't come in because Detective Dennis was the one who was on the case at that point.
All right. Thank you.
Too bad. Should have thought about that before he got up there and talked about someone being incarcerated.
Okay, so Mr. Steele, I guess you sort of led the charge on this, if I'm not mistaken. What do you say to the state's position that the court's decision to strike and prevent further testimony of this witness isn't a remedy that is permitted to the court by statute or the Constitution, and understanding that if this were reconsidered, the state would be, I mean, the defense would be permitted to cross-examine?
As Don Weinstein said, you can't unring the bell. The jury's already prejudiced.
So I believe that you have the authority, jurisdiction, and power to prevent a witness from testifying when that witness shows that they are not capable of providing a fair trial and intentionally, and that's my word, but it was clear to me sitting there that when Ms. Hilton asked retired Detective Dennis, tell us about this photograph that has Mr. Kendrick standing on top of a car, his initial lead into that answer is, well, Mr. Kendrick just got out of prison. And, you know, that affects Jeffrey Williams. Mr. Kendrick, as the court may have heard, is signed to Mr. Williams' record label. Mr. Kendrick, as you will learn, is at Mr. Williams' home on May 9th, 2022, when Mr. Williams and Mr. Kendrick are arrested. And it is just not that simple to unwind that instruction. It was an intentional, obvious infliction to denigrate this trial and prejudice Mr. Williams, Mr. Kendrick, and all. So you then have to do something about it. And what you asked to do is declare a mistrial. And you said, I'm not doing that, but there will be a sanction. So what are you going to do? So to me, that was the second time. The first time the court, I'm not saying it's not accurate.
So obviously, considering that I'm the one that imposed the sanction, I think it was an appropriate sanction. Address the state's argument that a trial court doesn't actually have the authority to impose that sanction.
I think that's wrong, based upon, let me give you, and I put it in my response, but Illinois versus Allen, 397 U.S. 337, it's 1970. What happened there, and the U.S. Supreme Court took down, that was an accused right to be present at the trial. Constitutional right.
State's trying.
And there's a dissent in it saying the accused, no matter what their conduct is, they could be gagged and bound. They have to be in the courtroom and watching the proceedings. Otherwise, it's a constitutional violation. But the majority said, this is ridiculous. Courts have to have the power to ensure that the trial is, and I'm quoting, conducted with dignity, order, and decorum. They are the hallmarks of a court proceeding. And then I found a case, I just found it amazingly similar. California versus Navarrete, Navarrete. Your Honor, it's 181 California Appeal, 4th, 828, 2010 case. And in that case, a detective is testifying, and there was a suppression motion granted. There was no Miranda rights given to Mr. Navarrete. And the detective testifies on the witness stand and said, Well, the reason I didn't follow up on this DNA swabs is based upon the client's or Mr. Navarrette's statement. The judge did exactly what you did. The judge called the prosecutor, well, a little different, called the prosecutor and defense counsel in chambers and yelled at the prosecutor and said, you know, I'm demanding, what are you doing? The prosecutor said, I didn't know that would happen. Just like here, I'm not saying that it was Miss Hilton eliciting that on purpose. I had no information that she would ever do that. But the judge said, well, this detective knows better. I find the detective is trying to harm this trial. The detective is barred. His testimony is struck. The direct is gone, and he can no longer testify. And the state did exactly what happened here. The state in California, the prosecution, the people, they called their next witness. To me, it's on all fours. The appellate court, Mr. Navarrete is, God forbid, convicted, and the appellate court then reversed and said, that remedy did not go far enough. That had to be a mistrial, that intentional conduct. And here, I'm asking the court, I believe that you have total authority. There is no way that anyone will convince me, I'm not the one who needs to be convinced, that Detective Dennis did not realize.
He knew exactly what he was doing.
He came out of nowhere. What difference does it make that Mr. Kendrick was released from prison 5 weeks earlier?
Yep.
What difference does it make? He did that to bring out to the jury that Mr. Kendrick was in prison for, and I'm telling you, it's a federal offense, a gun charge. There was no basis. So to me, to say you don't have the authority to do that, I believe you have every authority. If a witness comes in here and starts cursing, I'm using an example, I would assume, you are going to say, you know, this is just not decorum. You can't curse. The witness curses again. You're going to do something. You're done testifying. Courts have that power. So I believe that the state's argument that you have no power to control the proceedings is not backed up by the U.S. Supreme Court.
All right, thank you.
Very well said, Brian, as usual.
May I respond?
You may.
There was a defense attorney who raised their hand.
Good morning.
Good morning, Your Honor. I want to be very brief because I don't think what I'm going to add is truly what Your Honor is looking for. But
look at Yak helping him out, trying to hand him a mic. Shout out to Yak Gotti. Man, the Honorable Attorney Yak Gotti up here. Y'all saw him helping Mr. Weinstein the other day.
Jay Apt, Your Honor, good morning. On behalf of Mr. Kendrick, and I'll try to be extremely brief. Your Honor decided this issue in lieu of granting a mistrial, and one of the things I want to remind the court, really I'm just here to remind the court, is one of the reasons for this sanction, Your Honor, is because of, and I'm not pointing fingers at any particular district attorney, but the state's repeated unpreparedness, their repeated discovery abuses, and so this is a compound issue. And I think my perception is that the court finally had to say, okay, we're not granting a mistrial, but we got to do something. And if you now go back on that decision and reverse your own decision, you are essentially creating an incentive for the state to continue these, I'll call them mishaps, whether they're negligent or intentional. And I think the court is sending a clear and convincing message to the state that they need to be buttoned up, more buttoned up than they have been. And so I would ask the court, certainly the court has the authority, and Mr. Steele's done a very good job of explaining that, but I would ask the court to uphold its own decision to send that loud and clear message. Thank you, Your Honor.
Wow, very well said. We are going to name this gentleman Lil Doug. I hope he comes back. That was well said, because if you remember, Ms. Hilton, she even said herself, "Oh, Your Honor, I didn't know he was going to answer the question that way." Get your stuff together, man. Come on. We can't keep doing this. And Lil Doug made a great point. Ms. Hilton said it, and Judge Whitaker needs to get this court together because we've already been here 2 years too long.
Thank you.
Shout out to Lil Doug.
Yes, Your Honor.
Take this L.
I would agree with Mr. Apt to the point that
Mr.
I would like
Armstrong.
the court to uphold the determination that the court made, which was that it was not an intentional, willful act, as Mr. Steele has argued. I want to address both of the two cases that he referred to, Illinois versus Allen. One of the issue in Illinois versus Allen was a defendant who refused to act with decorum and was excluded from the courtroom, but was permitted to come into the courtroom if he was going to behave correctly. And so it went specifically to the offensive behavior for as long as the offensive behavior went on. We are asking the court appropriately struck the testimony that was at issue we are asking the court to go further with other testimony that was not the offending testimony. Now,
how?
People versus Navarrete is the only case the defense has cited to suggest that this specific remedy was permitted. That is a nationwide search in People versus Navarrete, Navarrete, is the only one that they were able to cite, and that is materially different in a number of ways. Number one, the facts are wildly different. The officer in the case was mad at the judge for excluding a statement that the officer had obtained, and actually had told people that when the prosecutor found out, told the judge after the fact, when they found out, that the officer had basically said he was going to do this because he was mad at the judge and would show the judge what for. That is not anything what happened here.
Wow.
And the reason that the appellate court in California decided that a mistrial was necessary in that circumstance was because of the specific evidence in that case, which is basically three things. You had a witness testifying the defendant had committed lewd acts against them. You had somebody testify they took about, I think it was a dozen or more swabs relevant to that. And then you had the officer testify, oh, I didn't think it was relevant to get the swabs because of the statement the defendant made that I can't talk about. The officer specifically said that because it would prejudice the defendant. And those are the circumstances in which it would, in fact, be incapable for a court to take that away. I would note before I go on to my main point about People versus Navarrete is that the California appellate court stated, we note that a trial court can almost always cure the prejudice of an improperly volunteered statement by granting a motion to strike and charging the jury with an appropriate curative instruction. This court did exactly that.
Stop it. Okay, Mr. Armstrong, do you know how many curative instructions have been given during this trial? Do you know how many disregards have been mentioned during this trial at key points? I mean, the jury already can't unsee the video. So you got the video in, just do with that what you will and move on and hope it was enough. But curative instruction, no. We're done. We're done with that. Y'all get your stuff together, and that's what Lil Doug was saying. You got to be held accountable at some point.
Jury with an appropriate curative
He's trying to Armstrong.
This court did exactly that. It was just the exact facts, how thin the state's case was on that issue, on basically the entire case. And the reason for it was why they decided a mistrial was necessary on appeal. More importantly, this is the case that they cite that says the remedy of preventing Detective Dennis from testifying further. This is the case that they use for that proposition. At no point in this decision does the appellate court address the legality of that. They simply don't do it. It is not addressed whether that was a legal remedy to occur. It's not something that stands for the proposition that the defense is citing it for, which is that the remedy to prevent Detective Dennis from testifying further is appropriate. And so they have not pointed to any statutory or constitutional authority, and under Rule 402,
yes, they have.
The exclusion of evidence can exist outside of that in the state of Georgia. Now, I'm sure, let me just strike that. So we're just asking that the detective be able to testify further in the case when the prosecution team determines that he is the person who's best able to testify to facts that are relevant for the jury's consideration.
All right, thank you. So I don't think that the facts in the California case are really that different than the facts here. Frankly, I think that an argument could very plausibly be made that the detective in this case was upset with somebody about his qualifications having been challenged and had made a decision that he was going to show somebody what he thought about that. I don't know that that's what happened, but I do think, like I said before, that the detective absolutely knew better than to have said what he said and did it anyway. And I have given consideration to everything that has been presented, but I am not going to change my decision about this.
There it is, right. Judge Whitaker.
I think that the next thing that you had to do was sort out the remainder of what we're calling the Ryan evidence. So if y'all want to present what you've come to agreement on and what still needs to be litigated. And
And we looked at an interview that Doug Weinstein did with Phil Holloway over on Inside the Law. And Doug Weinstein said, hey, listen, I know everyone's getting impatient that's watching on YouTube and in these live chats when it comes to mistrial. He said, Doug Weinstein said this, the foundation is being laid. And you see Judge Whitaker making her first sanction, if I remember right, the first sanction in this trial, period. And we're starting to get closer and closer to Judge Whitaker being forced to make certain decisions, because if the state continues to do what they're doing, Doug Weinstein said, we've got all this evidence building up to this spot. Now they're not preparing their witness. Now they have a witness up here who's saying some egregious things. And then you have the DA saying, oh, well, I wasn't prepared he was going to give that answer. Now, what's the next step from that? Judge Whitaker is going to have to make some tough decisions if and most likely when the state messes up. So we'll see what happens.
Thank you, Mr. Armstrong.
Thank you, Judge.
Doug Weinstein
Yes, Your
called
Honor.
it, though.
One small matter that's in this act we can address
Okay.
is in the CAD report. Okay. Never mind, Your Honor. Counsel and I have been discussing stuff in frequently. So
Yeah, I know.
I will turn to all that's left, to my understanding, is the last little bit of Blaylock's Instagram.
Okay. And do y'all want to give me some kind of, I don't know if it's written or whatever, indicator of what y'all have agreed to, or just put it on the record, or what's in, what's out?
Your Honor, I'm trying to think.
Or I guess, you know, if you don't have something at the ready, then I would assume y'all are on the same page about it and will abide by whatever it is you agreed to.
Your Honor, I believe that is accurate.
Okay.
I think what the state would be moving to enter into evidence is things that we've agreed upon or the court has already ruled on,
Okay.
besides what it is we need to discuss this
Okay,
morning.
all right. And so what is it that needs to get discussed this morning?
This morning, Judge, we're going back to content in Mr. Mr. Damone Blaylock's Instagram messages between him and third unknown parties. Your Honor had asked me to take a look as far as co-conspirator hearsay.
Okay.
From what I can tell, every instance I've found requires evidence really from the outside, that basically you could ignore this entire statement and there's still something to indicate participation in the conspiracy. I don't have any sort of law stating one way or another that that is what is required. I would just point back to the statute, Your Honor, that I think what Your Honor had referred to, I would say kind of are indicia of reliability, that they're talking about things that a person who's a member of the conspiracy would know about, and just simply that's not what's articulated in the statute. If it was supposed to be indicia, then I think we would be there, but that's not what the statute requires, so I don't think that would be sufficient. I think it truly does have to be from outside of that hearsay statement.
All right, and is there further argument from the state on that? And I know there was one, and there might have been two that we had already looked at that were kind of outstanding, and I had given a preliminary ruling subject to further argument on this. And the second one I think I already brought up, and I don't know, Ms. Abbasi, if you were here that day, but that I didn't think there was enough, so I have excluded that. But the other one, does the state have any further argument or authority on that?
So, Your Honor, I don't have the state's argument was in looking at 801 D2E, just the basic building blocks of if the court finds through the four walls of a statement, evidence in trial, or some other evidence the state would present. Ultimately, it is the court has to find that that other party, whoever they are, to a preponderance, are part of the same conspiracy against who it's being used against. And I will use, this is, I don't have a specific case for this principle, but I think it illustrates this point the state is making is if you had, take aside a gang conspiracy, say you had a murder committed and the defendant's phone, they get a search warrant, they extract it, and he is messaging someone after the murder that you do not know who they are. And he says, I need you to go to my house. The murder weapon's in my back bedroom in the second drawer. And they respond back, yep, the police, I can hear the sirens coming down the street right now. I'm going to go grab that gun. Where do you want me to take it to? And they have this whole conversation. You don't never know who he's speaking with. By my reading of, or an understanding of
what is he talking about?
That conversation, if you had it in that trial and we're trying to introduce it, I believe a court could find from the four walls, so to speak, of that conversation that person they're speaking with to a preponderance is a co-conspirator. And by that same analogy, if you have in the conversation that they...
So he's saying... So is he saying the person that the unknown person that whoever he's referencing is having a conversation with, they're a co-conspirator?
What?
You're losing me, brother. Let me...
Of that conversation, I believe a court could find from the four walls, so to speak, of that conversation that person they're speaking with to a preponderance is a co-conspirator. And by that same analogy, if you have in the conversation that the unknown party, so to speak, whether it's their Instagram handle, the fact that they're referencing specific individuals or that gang APD detectives have referenced are, say, YSL members, or they're discussing locations, or they're using gang identifiers in a private conversation, coupled with the evidence that that hasn't came in yet because no evidence about Blaylock to the jury has came in, but when APD gang detectives to speak about Blaylock and his Instagram and public and private conversations indicative of his own membership in the YSL criminal street gang, all of those the court can use or not use in making that determination. And so I don't have a seminal case that says you need more than the statement itself. I think oftentimes the statement itself, absent this kind of, in a gang context, there's other information versus when you have just, say, a murder case, you would, other than the factual analogy I just gave to the court, it would probably be hard to decipher. If you just had a single text with an unknown party, you wouldn't know who they are unless it was like the analogy I used. So the state doesn't have any additional case law.
What?
Right, and so what we have ultimately is that there is no evidence, none.
What? So if I tell my 5-year-old, hey, listen, we got nut. I'm going to tell you exactly what we did. All right. We went down to the store. This is what we were doing. Hey, this is what happened. Yeah. Oh, you know what you should do to cover it up? My 5-year-old says, you know what we should do to cover it up? You should go and dig a hole in the backyard and drop the gun in there. Nah, I can't do that. No, that'd be crazy. Co-conspirator. I have no idea what he just said.
I think it's a seminal case and important for a criminal street gang conspiracy, which all of Blaylock's are, the state's arguments related to them are not tethered to the murder of Jamari Holmes. They're tethered to the YSL criminal street gang. At least the ones that are in dispute, I should say.
All right, so can somebody remind me where it is that we're going to find the statement specifically that we had been paused on before?
I don't know if this, I'm sorry, excuse me. I don't know if the state sent to the court a new link or we're still
I'm
on
sure
the
there was
prior
a
one.
link that y'all sent me at some point.
I can create
over and over again. I know. I'm
Yes.
sorry.
for a
The most recent one.
Judge Whitaker said, what are we talking about again?
When that was, I could probably find it. Or
The-
what folder it was in.
Yes, Your Honor. The initial folder was 9 October centralized motion folder in Dropbox. For efficiency's sake, I can quite quickly create and
That would
send.
be wonderful. A new link.
Yes, Your Honor.
Okay. And I I guess it'll be easy enough to see once we're all looking at it again. But I cannot remember whether in this particular one that we were talking about, there was anything like the other speaker's handle or anything like that that would have been outside of the statement itself. So I guess when we get the link, we can look at that.
I guess.
And Your Honor, I'm going to try initially to email because Blaylock's Instagram is 28-page PDF. So I think that should be small enough to send via email.
Okay.
28 pages of Instagram. Shout out to the Instagram RICO. That's what we're going to nickname this. It's a RICOIG. All right, so let's skip ahead a little bit here and see if Mr. Atkins can get his shit together. Online racketeering.
That email has been sent, Your Honor. I utilized the Zoom link email that Ms. Percival had sent. If anyone does not get it, please let me know.
Okay, thank you.
Congratulations to Fulton County for creating the first internet RICO. Johnny, it's pretty straightforward. Johnny said, actually, I didn't ask you this before. What are you doing if you're on this jury? When it comes to the RICO charge, which is the part of this case, the state has done zero to show that this was an organization that was out here conducting organized crime or encouraging organized crime. If anything, Thug was trying to pull away from some of the stuff that was going down, and maybe he had a beef with a person or two, but he wasn't even the one out here doing anything or encouraging it. So yeah, it's pretty simple at this point. Shout out to Sean in the building. Gang in here. CEB gang for life. Y'all give me one. Y'all give me 1 second. This is crazy.
All right, so it was at some point after the 293 one. It may have been the one directly after that.
Your Honor, I believe we had the court's preliminary ruling of admissibility pending additional case law from defense ended on 344.
Right.
And so there's only, I believe, 5 PDF pages left for Blaylock. And so it will start in PDF page 13, Instagram page 359.
Right, but my preliminary ruling pending the additional case law is still a preliminary ruling. And
yes, Your Honor.
So the conversation, if you will, that starts on
342.
342 and goes through 44?
Yes, Your Honor.
Okay, that's the one that it was only a preliminary ruling. And so the person whose true identity is unknown, is their handle Snake Life Maniac?
Yes, Your Honor.
Okay. All right. And did I understand your argument to be that the court could take into consideration in determining something outside of, if there's anything outside of the statement itself or the conversation itself that would indicate kind of a co-conspirator nature, that the court could and should take that into consideration?
Yes, Your Honor, and what the state's referencing in regards to that is the totality, specifically or almost exclusively from APD gang detectives, which started with Detective Belknap, the first witness in the trial, in terms of, like, for example, and there's also, they're discussing, someone references Pokey, which has come up periodically in this trial and is one of the individuals that Quindarius Zachary mentions was participated in the shooting of Miss Reed's home, right, when he's discussing Kenneth Copeland returning. And also when this snake life maniac, when Blaylock, who's one King DO1, states he was stamped into the street gang by Pokey, the individual responds, he's been locked up a good 6 to 7 years. When did you get stamped? And he's kind of checking to see if that story checks out. And so the state's argument, and then it of course continues on, but it's, and the Snake Life Maniac says, I never met the young rock crew. There's been a lot of testimony about rock.
Right, but if if I have to find something outside of the statement itself, then that would indicate, I think, that I can't take into consideration the contents of what this unknown person is saying to make that necessary determination, right? So
the state's understanding and argument is that you can use, whether it's this statement itself alone, the court just has to find to a preponderance that this
well, we
individual
know
is
that the statement alone can't establish the existence, or I'm sorry, the participation of the declarant in the conspiracy. I mean, that the statute itself provides that much information.
And I guess my argument, Your Honor, is that the testimony in trial is in addition to the statement. As in, like, if you just had this in a vacuum and I presented no other evidence of why what they're saying is significant, if you didn't have APD gang detectives who've testified about what these indicate or mean.
So because we have outside of this statement testimony about Pokey and testimony about how people get included in gangs and things like that, is
yes,
that
Your Honor.
your argument?
That's the state's
argument. And in
argument.
addition to that, this person's handle itself indicating their connection to YSL?
Yes, Your Honor.
All right. Okay. A preponderance is really not that high of a standard burden to meet. So I am going to find that this one does meet that outside of the statement alone, so that entirety of that can come in. So we then need to move on to whatever was left. Is that right?
Yes, Your Honor.
Okay. All right, and so the next one would be
Judge
on
Whitaker
page
got it, so
430?
that's why
or
she's the
there's
judge.
some that y'all have,
359, Your Honor.
oh, that's a different one? Yeah,
It's a different one.
Yes, okay, so 359.
And Miss Love is not here today, so
what's
her body
highlighted
might be the man.
is Blaylock stating you have to pay the dues January 15th. That's the day you got stamped. And then the individual responds back essentially like he will pay him when he sees him. The state, I will, because this conversation is so brief in terms of comparatively to the one before, the state will concede or not utilize 359.
Okay. So y'all will withdraw that one.
But with yes, Your Honor, 430. So the individual that Blaylock is messaging, YSC Prince, he says he's leaving that YL up to you and me. YL is Young Loyalty. So when YSL, the criminal street gang, you have remnants of, Young Loyalty is essentially a subset of that. And so when he said he's going to leave YL up to me and you, he said when he gets out, it's still going to be YL, but we're going to take it over, basically. Let's push up next weekend. The state wanted to include that because of direct reference to Young Loyalty and someone having to take it over. This would be in conjunction with, which I don't believe or do not recall, testimony thus forth in trial, as in through Detective Belknap, or will be when Detective Viverito testifies about Young Loyalty YL. But that was the state's request or argument in terms of this would have to be, the court would have to deem YSC Prince making that statement is in furtherance of the conspiracy to admit this as an exception to hearsay.
Okay, and you're saying we don't thus far have any evidence about YL or the meaning of YL, and are we going to get any?
Nope. Your Honor, yes, the state, I am drawing a blank if Detective Belknap addressed that when he first testified in this trial. I just do not recall as I'm sitting here, but.
Right, and so what we have ultimately is that there is no evidence, none.
This man said, he pulled a little Woody. He said, I don't recall. I got to get that for the soundboard. I'll make sure I have it tomorrow, y'all.
If he had not, the state would proffer that Investigator Viverito would discuss that at a future date. I do not have any additional evidence.
And YL is, how is YL furthering this conspiracy? I'm not following your argument. I'm sorry.
Nobody is. Judge
So
Whitaker.
Young Loyalty YL is a part and parcel of YSL. It's like a subset. And so the state, by him saying we're going to take over specifically YL, that is trying to assert leadership over Young Life.
Hey, have y'all heard of YL before? This is exactly what he's saying. What he's saying is two people that were allegedly in YSL, they posted on Instagram something saying YL, and now he's saying that YL is a subset of YSL. What? Yikes.
Or Young Loyalty.
They're just making it up as they go.
That one seems a bit, I don't know, far afield.
Understood, Your Honor. The state will not utilize 430.
Right.
And the last one, Your Honor.
Thank goodness.
Ms. Atkins, do you mind if Your Honor, can I just interject?
Sure. I mean, they're withdrawing it and/or I'm excluding it. Okay. But so do you need to?
No.
Shout out to YL. We got a new gang, y'all.
All right. So 2145.
And Your Honor, the last thread of this nature is when you go to page 446, there's just one line where Blaylock is discussing, he says, you're not slime, and on 447, they go back and...
I don't see a 446, 447.
It is PDF page 15, Your Honor, and PDF page 16.
Okay.
Sorry. And the key, the statement that the state is seeking to introduce is when Blaylock on page 447 states, I stamped you in slime behind the Blue House, talking about the, bringing that individual into the gang. The 446 is only included for brief context to that.
Why else the baby slimes?
The state would not necessarily have to use 446, but the argument is that when Blaylock states, I stamped you in slime behind the Blue House, to this individual, when they're going back and forth about if that individual is slime, that statement, the state believes there's two arguments for this statement in terms of Blaylock definitively stating that he brought this individual into a criminal street gang, and he references the Blue House of just a specific location to remind him where he stamped him in. That statement is a co-conspirator statement, but in addition is a statement against interest. And the best example of why it's a statement against interest is the case of this nature. As in, if Blaylock was in this physical courtroom right now, that statement he made there is against his interest in terms of definitively asserting he has enough rank in a street gang to stamp someone in, and would be evidence that could be used against him in a criminal street gang or RICO predicated on a street gang trial. And so the reason that the state articulates that this is 801 D2E is because when he's telling someone, you know, I stamped you in slime behind the blue house, it's a conversation between, he's asserting in this statement that he brought this person in the gang. And so those kind of conversations, they have to be able to speak freely amongst each other, and they're discussing criminal street gang activity in terms of he's referencing when he brought him into the gang. And given the liberal standard of admissibility from Kemp and its follow-on cases, and that fostering cohesion, also, you know, the direct reference to the exact criminal street gang conspiracy that the state is alleging they are a part of, feels that Blaylock's statement, I stamped you in slime behind the blue house, should be admissible under either of those two bases, Your Honor, is the state's argument for why it's not hearsay.
All right. Why, I think that one passes muster. Yes, sir.
It's a reach. Big reach.
I believe that a statement against the penal interest, as articulated by the prosecutor, if it only goes to Mr. Blaylock, that we would get a limiting instruction.
I think it comes in as a co-conspirator exception. The I stamped you in slime behind the blue house.
Okay, and understand the court's finding, then I would ask you to decide whether 24-8-805 hearsay within hearsay would apply, because I don't see the exception on the other end of the conversation. I don't see I stamped you in. The other person's statement is also 801 D2E.
The other person's statements, frankly, are GMFU and you not.
So how did
I mean, I don't
that conversation
think
further
it seems I don't think it does, but I don't think those statements are being offered.
She's saying they're not hearsay, but they also don't prove the state's case, is what she's saying.
Right,
so if they want to bring it in, bring it in.
Your Honor, that, and correct me if I'm wrong.
She's basically saying it's a waste of time, but they want to bring it in.
All of the remainder of this are conversations we have discussed that are pertaining to the February 23rd, 2019, the night of, day of the murder itself, not gang co-conspirator statements. They're tethered to, they're ones we've discussed of no issues with. Unless the defense counsel corrects me.
That's
accurate.
right. Okay. All right. And so is that it for
That's the entirety of Mr. Blaylock.
Ryan evidence? All right. And when are we, you know, we discussed before about how we need to get to this kind of grouping of evidence before the end of this month. Is that going to happen?
Your Honor, there is yes, Your Honor, the state, we could reach this case today.
Okay. All right. Sounds good then. And then how about the Mr. Arnold scheduling? Is that gotten nailed down?
We can approach.
Okay.
All right, so we're approaching. We're going to skip ahead here in a second. Let me see. I wanted to read some of these super chats real quick before we move forward. Shout out to Amy in the building. The awesome, amazing Amy gifted 5 memberships. If you got a membership from Amy, make sure you say thank you. Shout out to Amy. Also, The World's End has been a member for 2 months. Says, hey, Fanny, pick your jaw off the floor. Get your attack dogs better organized. They struggling, man. They're struggling. And also, shout out to, I don't want to say your government name, but someone sent $10 over on the Cash App. I appreciate you. Thank y'all for the support and love. And I'll be reading more super chats throughout the show. Y'all let me know who was that? Because I don't want to say your full government name if you don't want me to. So just let me know. And I would say your Cash App tag, but that's your full government name too. So thank you either way. I love it.
All right, because we are waiting on the arrival of a juror, we are going to At this point, I'll entertain argument on our outstanding issue of whether an overt act not included in the indictment might be able to form the, and this is obviously hypothetical, but we need to sort it out, the sole overt act that a jury finds in support of guilt on count 1, the RICO count. So whomever wants to open up that argument. And I know y'all both wrote briefs, but if y'all can brief me, that would be helpful.
Your Honor, I think this was the state's argument for why that would be acceptable.
I think you're right. And it may be that, I don't know if anybody in court right now is ready to argue that, or if y'all need to call Mr. Armstrong back or somebody else from the DA's office. Okay. All right, why don't we take a recess while whomever's going to argue that for the state arrives, and we'll be back in a few minutes.
All right, so we've got more motions we're trying to get through because the state is just getting demolished this past 7 days by the defense. So we're going to go and see if they can possibly win this one. Let's skip ahead a little bit. Shout out to the delay gang too. And thank you to everybody who's liked the video so far as well. Appreciate y'all.
Do we still need to sort out anything about the evidence that's going to come in with Wooney Lee? Because I see that witness is on our list for this week.
I thought we discussed everything that was in his folder, Your Honor.
Making sure.
I didn't know that we had gone through all of his Instagram posts. I don't know that all of it will be relevant, although it depends on what he says on the stand. I don't know if the state would agree or disagree with that.
Sure. Just want to sort out what we can while we've got time beforehand and not have the jury waiting, because Lord knows they have to wait on us enough as it is.
The jury's been waiting for almost 2 hours now. Sheesh.
They were waiting on them.
Granny Mo, you know the answer to that. Granny said, why is she asking Armstrong to argue for the case? Well, Fannie has got some of these district attorneys on the chopping block, so. That's Miss Abbasi right there. Man, they are dragging this morning. So we're about to lose all of our delay, y'all. Jeez.
Where did Misty Williams go?
This is the restroom.
Okay. Well.
Good morning, everybody. We're doing our part. I see y'all saying y'all got to get Fannie Willis out of here. So we might be taking an early break. I'm going to see if I could find some of these motions that were filed too for y'all so we can go over them. Let me see. Let me see if I could find it here. Man, we just got a lot of dead time. Hold on, let me skip ahead for y'all. It seems like they're just doing some homework right now. Good morning, everyone. I'm gonna skip ahead a little bit too. Oh, it looks like Miss Love is back. Oh man, that's unfortunate. But we can't hear anything. I think they forgot to turn the sound back on. Dang, Law and Crime. I don't know if it's them or if... Hold on, let me try this other one. I don't know if it's them or if it's the actual media people that forgot to turn the sound on. Yeah, it's the media. Dang, man, we don't know what's going on here. So it looks like we're officially off of delay gang because something's going on here and we can't hear. And then once they're done with this section, they actually go to another break. So what I'll do is I'll pull up a couple of those motions that we talked about earlier that Judge Whitaker was ruling on, and then we can come back and see if they're back yet. I want to see if the sound comes on though. They're still waiting on a juror. Okay, looks like we're officially to our break. So let's go through some of these motions here. So this is the one that the state filed that Judge Whitaker said, nope. And this is for Detective Dennis and everything that went down last week. So y'all check this one out. This is the state's motion to reconsider oral order striking witnesses' testimony and related exhibits. Comes now, the state of Georgia, and respectfully moves this honorable court to reconsider its October 17, 2024 oral order striking the October 17, 2024 testimony of witness retired investigator T. Dennis and related exhibits, and precluding his further testimony. And y'all saw Doug Weinstein went in on the state, and he made sure Judge Whitaker clarified that Dennis would not be coming back, which she stood on. As a sanction for an inadvertent, stop the cap, non-responsive answer during his testimony. In support thereof, the state shows the following background. During Investigator Dennis's testimony, Investigator Dennis, we're just going to call him Dennis, referred to actions defendant DeMonte Kendrick performed immediately after his release from custody. Defendant Kendrick moved for a mistrial, which this court appropriately denied. How they say she got that right. As a sanction for this event, however, the court struck the entirety of Investigator Dennis's October 17, 2024 testimony, precluded him from testifying in the future, and struck from evidence exhibits which include which Investigator Dennis had authenticated on October 17, 2024. The scope of the state's claim. It is appropriate for the court to strike a witness's answer from the jury's consideration when it contains information the court finds the jury should not have heard and should not consider. The state does not contest that part of the court's ruling. The state submits, however, that the order striking the entirety of the witness's October 17, 2024 testimony, precluding the witness from testifying in the future, and excluding exhibits which had been admitted through the witness on October 17, 2024 was improper and an exclusion of evidence which the law does not permit. The state thus respectfully moves the court to reverse those portions of the court's oral order. And we heard Mr. Armstrong talking about this section to where he said, hey, you really don't have the right to be able to exclude this evidence, especially after it was allowed in. And that's the problem and the issue that they're having with that. Analysis. Evidence exclusion is an extreme sanction and one not favored in the law. State versus Smith, 308 Georgia, 345, 354, and so on and so forth. This is so strongly a part of Georgia law that even the most well-established privileges are narrowly construed as the ascertainment of as many facts as possible leads to the truth, the discovery of which is the object of all legal investigation. And that was cited from Burns v. State. OCGA 244402 provides in relevant part that all relevant evidence shall be admissible except as limited by constitutional requirements or as otherwise provided by law or by other rules as prescribed pursuant to constitutional or statutory authority applicable in the court in which the matter is pending. So this is kind of what Judge Whitaker had to fight against, saying, hey, listen, I have authority to rule over this because this man went on the stand, did something he wasn't supposed to do, and prejudiced the jury. And honestly, she said she could have called a mistrial because of that. But the reason she didn't is because what he talked about is going to be brought up at a later date. But can y'all imagine? I mean, the position Judge Whitaker would have been in if they weren't going to bring up that Yak Gotti had been previously arrested or that he was just getting out of jail. That would have been a major issue. And I would have liked to see what Judge Whitaker did in that case, but I guess we'll never know. That is Rule 402 forbids a court from excluding evidence unless constitutional or statutory authority authorizes that exclusion. Here, no constitutional or statutory authority authorizes the exclusion of the non-offending portions of Investigator Dennis's October 17, 2024 testimony, of his further testimony, or the related exhibits. where a purported ground for evidentiary exclusion does not come within the exceptions enumerated in Rule 402, it finds no home in any of the specific and detailed exclusionary rules included in the new code and is unsustainable. Okay, and here's the code here. We don't really need to read through all of that. So we'll skip ahead to this part. This is consistent with federal interpretations of the corresponding federal rule of evidence 402, which has a prospective effect in that it precludes the trial judge from further creation of the new exclusionary rules of general applicability. Interesting. While OCGA 246611 permits a court with control over the mode and order of the witness examination, Rule 611 does not authorize an order excluding evidence and thus would not justify the order at issue here. But it seems like I'm trying to think if the same thing happened with Woody's testimony. I don't think they excluded any evidence that was brought in. Yeah, because when they disregarded all of Lil Woody's testimony that took place after the ex parte meeting and before Judge Whitaker took over, they just excluded his testimony. And I honestly don't remember. I'm trying to think of what evidence was brought in at that point. Maybe a couple social media posts. But from what I understand, the evidence was still left in. And it was actually used at other points as well. Meaning being Monk Tunk's video that he had on social media and a couple other things. So Rule 611, it says mirrors federal rule of evidence 611 as that rule read in 2011, right? Smith v. State 299, Georgia 425. Okay, all these numbers. Thus Georgia courts look to federal authority for its interpretation. The state submits that federal authority of appeals are very clear. Rule 611 does not authorize the wholesale exclusion of evidence. Unlike the vast majority of the other evidence rules, Rule 611 does not purport to regulate the admissibility of evidence. Instead, the rule gives trial courts broad powers to control the mode and order of what is otherwise admissible evidence. So they can say if it's going to be allowed in or not, but they can't take it out. What? That's interesting. I'm not seeing that there. And let me see what y'all are saying in the chat too. Let me see. Amy says, my opinion is she's giving the state advice, to level the playing field. Could be. Shout out to everybody who's just stopping by in here as well. The state definitely does not want Ashley Merchant because she will definitely cook the state well. She's going to be representing Mr. Arnold, who's going to be apparently testifying here soon. So we'll see what happens with that. Unlike the vast majority of other evidence rules, Rule 611 does not purport to regulate the admissibility of evidence. Instead, the rule gives trial court broad powers to control the mode and order of what is otherwise admissible evidence. Although decisions that a court make under Rule 611 may indirectly affect whether proof is admitted, the rule does not provide an independent ground for excluding otherwise admissible evidence. And you know what's funny about this? We talked about this with Judge Glanville when Brian Steele was trying to get him to recuse himself. A lot of these judges rule on their own decisions, which is really weird. It's really strange to see how this is laid out because they're basically saying, hey, Judge Whitaker, you have to make a decision on whether you're allowed to make the decision that you made. And I mean, what judge is going to, I'm sure there's some of them out there, but what judge in Fulton County, I should say, is going to be like, you know what? I probably shouldn't have made that decision. You guys are right. I'm going to say I don't have the power to make that decision. I don't know. I would like to think Judge Whitaker would be a judge that would do that, but it seems like there needs to be maybe the Georgia Supreme Court, like Brian Steele had to do in Judge Glanville's case, that would have to step in for them to say, all right, I was wrong. Yeah, definitely wishful thinking there. Here we go. Where a trial court ordered such an exclusion, the Fifth Circuit held the court erred as a matter of law and therefore abused its discretion in relying on Rule 611 to preclude the government from calling the witness necessary to present admissible evidence. Further, the matter at hand does not involve evidence which was illegally seized under the federal or state constitutions, and it does not involve a violation of other rules which have a statutory provision for exclusion, such as the reciprocal discovery rules in OCGA 1716-6. I'd be interested to read that. I wish they had it in here. As there is no constitutional right or statutory provisions which authorize the exclusion of former investigator Dennis's October 17, 2024, or future testimony generally, or the exhibits related to it, the order excluding such evidence was in error and should be reversed. For these reasons, the state respectfully moves the court to reverse those portions of the court's oral order in which it struck the entirety of Investigator Dennis's October 17, 2024 testimony, precluded Investigator Dennis from testifying further, and excluded exhibits which had been admitted through Investigator Dennis on October 17th. And they submitted this that day. Boy, they were quick with this one. And that was Kevin Armstrong, who we just saw in court earlier, and he took that L, as many of y'all know. So, I mean, they definitely make some interesting points. Obviously, most of us are looking at this as non-lawyers, and it seems like they made a decent case. The only thing is, what Detective Dennis did prejudiced the jury, and all the statements made up until that point, everything that was allowed in, it's now tainted. So I don't know. I think Judge Whitaker made the right choice. Y'all have to let me know what you think. Rebecca said, who is Arnold? Arnold, his street name is Duke, and he is represented by Ashley Merchant, which I actually wanted to get in here in a second, because I have a letter that Ashley Merchant wrote to the state basically saying, hey, all that stuff that y'all tried to pull with Monkton, everything that you pulled with Lil Woody, you're not going to pull with my client. So he'll do what he said and what he agreed to in his plea deal. But other than that, we're not going to issue any warrants forcing him to appear. The only thing we're going to go by is what was in this plea deal. So Ashley Merchant's already kind of getting ahead of the game with this letter. I'm going to see if they can find it, but I want to check and make sure we're not back in court yet. Let me see. Are we still on a break? Yeah, we're still on the break. And let me read some of y'all's comments too and see what the chat is saying. Oh, Amy, of course, reminding y'all, please like the video if you haven't liked the video yet. We've got 740 likes, 1,500 of y'all in here. If you could take a second, just like the video real quick. It's free and it does help the channel continue to grow. Yeah, we talked about this on Friday. Phenomenal RN says Monkton's lawyer was terrible. Reviews on, oh, he does? He has terrible reviews online and he has been disciplined. Oh no. Really? I'm gonna see if I can find it. Where do you find, let me see. Derek Wright reviews, Fayetteville, Georgia. There he is. Oh man, jeez. All right, y'all want to do this? We're gonna have a Derek Wright roast session. Shout out to Phenomenal RN. Oh, this is tough. And I shouldn't laugh. This is bad because Monkton's going to jail. But let me make sure that y'all can see most of this. Okay, we're about to have a Derek Wright roast session. These are Derek Wright's reviews. Y'all want to look at the photo? Let's see if I can zoom in. Oh my God. Here we go. He's got 63% 5 stars. Let's see what some of these reviews are saying. All right, Derek Wright. This is in September 10th So this was last month from Anonymous. Worst. Hired him for my son 10 years ago. Watching him on the YSL case brought back just how horrible of an attorney he was. He would not show up or was late. When wanted a jury trial, he said take a plea or pay in full. He is about money and should be called king of plea bargains. Dang. And this one's actually from last year. It says worst attorney ever. Attorney Derek Wright. This man is a crook and a liar. He abandoned my son's case and he's only been hired for 3 months and refuses to answer any calls or texts to explain why he thinks he's going to take our money and abandon my son's case. He never showed up for court on time or visited my son. He made promise after promise and assured us he would fight for my son. He used a juvenile excuse saying me, the mom, called and texted too much about the case. How else was the family supposed to get updates on the case because he never called or did the job he was paid for? I wish I had seen negative reviews on FindLaw of other clients complaining about how incompetent he is before we hired this clown, or even the complaint with the board that shows his history of being a liar. What? Uh-oh. Do not hire this wannabe Johnny Cochran because he doesn't have the experience to do the job. If you do hire him, you'll regret it. Save yourself the trouble. He is a hypocrite. Oh, man. So we got to go to the bar and see. Hold on a second. We got to go to the bar and see what's going on. So let's go. State bar complaints. Let me see if I could find Georgia bar. Here we go. We're going to do some research and see. All right. Yep. Fayetteville, Georgia. Here we go. So he is an active member in good standing. All right. He's got his bar card here. There's his phone number if y'all want to call and send him some lunch. Tell him how great of a job he did, which I think you should. Status, active member in good standing. Okay, that's good. Public discipline, history on file. He joined the bar in 1995 and he went to Georgia State University. All right, we'll read his bio in a second, but we want to see this history. Okay. So it's saying what the site only includes. And then it looks like in 2006, he had a review panel reprimand. Now, what was that for? Are we going to be able to see what it is? Oh, interesting. Okay. So we're doing some research here live in 4K. Let me zoom in so y'all can see this. This was back in 2006. So y'all know technology wasn't the greatest back then. We were struggling in 2006. Right? Obama was about to get in office. We needed some help. Here we go. Supreme Court of Georgia. Oh, man. The Honorable Supreme Court of Georgia met pursuant to adjournment. The following order was passed. In the matter of Derek M. Wright, this disciplinary matter before the court on Derek M. Wright's petition for voluntary discipline, in which he seeks a review panel reprimand and requirement that he attend the bar's ethics school at his own expense. Wright, who was admitted in 1995, admits that he filed a tort action on behalf of a client. What? But failed to respond to the defendant's discovery requests and motions. Failed to comply with the court order. What? Failed to appear at a scheduled hearing. What? Failed to inform his client that their action had been dismissed, and then lied to the investigative panel in an attempt to excuse his failure to attend the court hearing. Oh, man. Gosh. Oh, dang, Derek. Such conduct violates Rule 1.3, 1.4, and 8.1. We know these are the rules of, I think it's professional conduct or attorney conduct of the Georgia rules of, oh, okay, there it is right there. Professional conduct, part of the bar rule 4-102D. Wright had no prior disciplinary record and states he is genuinely remorseful and accepts responsibility for his misconduct. The state bar and the investigative panel concur in the petition. After a review of the record, we accept the petition and hereby direct that Wright receive a review panel reprimand and that he attend the next scheduled session of the state bar's ethics school at his own expense. Oh my gosh. That's interesting. I don't know. I would like to hear the other side of the story and see what happened or what his excuse was. I mean, y'all got to see him on the stand and kind of how he moves a little bit. So I don't know that it would be a good excuse, but dang, this is crazy. Do they have a bio of Mr. Wright too? And I'll post this later so y'all can watch it. It doesn't really have anything. It just shows where he went to school. He's in criminal law and family law. Would y'all hire Derek Wright at this point? Let's see. Okay, he's got some good reviews. Okay, this was from 2022. Let's see what this one says. I see so many comments about incompetent, thief, unreliable, etc. Now, I have known Derek Wright for over 30 years. Okay, well, we're not reading. Over 20 years. This one seems a little bit biased. Y'all want me to keep reading it? We'll give him his flowers. For over 20 years and have been a very reliable and responsible. Okay, it's a weird sentence. I have called him myself, and it will be a minute before he returns my call, but he do return them. He is a very busy man because he comes highly recommended. Y'all, please let's be fair. Who wrote this? And not bash him until he proved himself incapable of being a great attorney for your team. Famous last words. Oh, Lord. I promise, if y'all be fair, give him time, you will win your case. This is what I experienced with him. I have used his services twice and I've never been disappointed. Let's be fair, guys. F-A-R-E. Oh, Jesus. Federal case. Extremely knowledgeable, professional, well-prepared attorney. Without a doubt, one of the best in the nation. This is from 2022, that same year. Not sure what's going on, but highly disappointed. I have dealt with Derek several times and have recommended him to a few people I know. He had always been solid with me and responsive. In February of 2022, I called him and asked about filing a divorce for me. He told me he could do it and to send him the details he needed with $700 to start filing. I cashed out him the money and things went radio silent. I reached out a couple times. Sometimes he responds. Most of the time he doesn't. It's been 2 months and I can't find anything with the courts regarding my divorce. Oh God, 2 months? I mean, after 2 weeks, I'll be like, hey, y'all, we got to get this thing done. I reached out to the state of Georgia bar and they advised me to send either an email or a certified letter to Derek. Contact the client assistance program at 404-527-8759. After that, file a grievance with them at the Georgia bar. And here's where you can file. I'm one step away from filing the complaint, but all I want is my money back or proof the divorce has been filed. Jeez, I wonder if there's one as far back as 2006. Wouldn't that be interesting? It looks like it only goes back to 2009. I'll be interesting to see. All right, let me double check and see if they're back in court yet. Still not back in court. I don't want to continue to roast Mr. Wright because I mean, the worst possible thing that could happen to an attorney, I think, happened live in 4K. Kim Possible says, read Antonio Sledge is next. Did he leave a review? I'm going to see if I can find it. Y'all are saying Antonio Sledge left a review as well. Sheesh. Mr. Wright is the best lawyer in Atlanta.
Stop the cap.
He did. You're kidding. Hold on a second. I was extremely disappointed. Okay, which one did I just read? 20 years, extremely knowledgeable, disappointed. How did I miss this? Oh my God. I cannot believe this. Did y'all know this was in here? Five stars. January 10th, 2022. Posted by Antonio. Best lawyer. Oh my gosh. I, Antonio Sledge, truth, Mr. Wright was my life in the courtroom. He is the best I ever hired. He away, be honest with me about a case, to always pick up the phone when I called. Never let me down. What? Oh my gosh. This is crazy. Rice Street said that didn't age well. There is no way this is real. Oh man. He said, never let me down. Now, Antonio Sledge's sentencing took place last year, and he had Mr. Derek Wright. He said he had known him for a minute for the year before that. Wow, this is tough to read. Yeah, I'm with y'all on this one. This did not age well at all. Always pick up the phone when I called. Never let me down. I mean, that's tough. Especially after everything that happened. Oh my gosh. Y'all want to keep going? I don't know if any one of these can top that one. What do y'all think about that? Wave Lori said he was appointed, right? Yep. Did the prosecutor get scared? They just cut out. Kimberly said you beat me to it. Incompetent, inefficient, inept, incapable. Ouch. Yeah, we'll read that one in a second. They're raising money for him to get Ashley if she can represent him. I mean, what are they gonna do? This is Kappa Kappa. Young Step is in here. He said, oh, okay. So Young Step is talking about life. We'll get to that a little bit later, Young Step, but good to see you in here though. What does he say? He says, so at ClassE, something happened, bro. I got a scholarship from the Texas Longhorns because of how well I performed in varsity. Congratulations, man. He going to college. He's going to be at Kevin Durant's alma mater, I believe. Oh, that's dope. That's dope, man. Congratulations. He put his own reviews. Y'all think best in the business, Mr. Get It Done, indictment slayer. Okay. Mr. Wright is an exemplary example of what an attorney embodies and what an attorney should stand for. Mr. Wright is just good old fashioned, gets the job done. What you ask of him, he will make it a reality. Everybody's case is different, but if you walk into a courtroom with Mr. Wright, you're in great hands.
Stop the cap.
Yikes. Just good old-fashioned gets the job done. What you ask of him, he will make it a reality. Everybody's case is, oh, okay, I just read that. Everybody's case is different. He is respected in every courtroom from Fulton County to DeKalb County and is taken very seriously by the DAs. Personally, he has successfully defeated 3 separate felony indictments that were non-related that happened at 3 different times in my life. Oh, man. This dude is a menace. He has won a motion to suppress hearing from me. Very impressive. You rarely see that live in action when it counts most. He has preserved my freedom and innocence on several occasions. And for this, I am eternally grateful. Honestly, Mr. Wright is Mr. Wright. If you want someone who is articulate, sharp, cunning, and will actually win, he is your guy. If you want someone to exceed expectations and that always has the right game plan, call Mr. Wright, I guess. Wow. What else are y'all saying? Shout out to Kirsty Ann, excuse me, has been a member for 2 months. Said, please, can you take my what has gone down? I've been at the hospital, Haven, dental surgery, and just got here. Can you take my... I don't know what you mean, Kirsty, but do you want to know what we're waiting on? Right now, we're waiting on a juror to get back, I believe. So we're just buying some time roasting Mr. Wright up in here. Jeez. This is tough. Let me see if they're back yet. I don't think they're back. The camera's moving, but thank you for that. Oh my gosh. This is crazy. Yeah, shout out to the Longhorns out there. Unita Sim says, I believe Monktunk knew he was going to violate, but he just wanted to get home at that particular moment. Well, he knew what he was signing wasn't true, but it's clear you have to get on the stand and you have to acknowledge your factual acknowledgement. So you just can't sign it and say, oh yeah, these are facts, and then get up there and say, no, they're not facts. That's a great way to get locked up, which is what happened to him right now. Amy's reminding y'all to like the video. Thank you, Amy. I appreciate it. Let's see. Yeah, Kirsty Ann said, tell me what's going on. I got you. Let's see. Cars, Cats, and Aliens. That's an interesting name. Says, I owed my lawyer 22 years ago $200 out of the $4K I spent. Yeah, and there's always 2 sides to the story, so I don't know how many of these are legit. I can't believe, first of all, this bar complaint, which is crazy. And then you got Antonio Sledge in here saying he's the best lawyer. Oh, man. My. How the tables turn. This is crazy. The World's End said, recap. Prosecution lost their motion for Detective Dennis. They have much of their motions defeated. Yes. So Judge Whitaker is, he's tightening the leash on the defense a little bit. I'd rather take my chances with the public defender than pay real money for right. Sheesh. Rico Blaine up in here, taking more shots. Here's one. This is a tough one to read. Incompetent, insufficient, inefficient, inept, incapable are just some of the words that come to mind. He arrived late to my court hearing 3 out of 4 times, and this made it impossible to build a good rapport with the judge. He was unable to fully have the case prepared and made a fool out of himself in court. I never had a chance. Whew. That's tough. Malcolm is giving him some love. We got Jack's guy in here giving him some love. DCE is reminding you to vote early. Yeah, make sure y'all do that. And good morning, everybody else is in here. Make sure y'all go vote. I voted on the 15th. No, wait, is that true? Did I vote on the 15th? I think I voted on the 16th, but I voted as soon as I could and got my vote in there. Hopefully we can get Fanny out of here, but I don't know. It's gonna be tough. But y'all make sure you get out there and vote. Still not back in court yet. I'm gonna see if I can find this letter from Where did it go? From Ashley Merchant. I'll find it here in a second. But before I get to that, let's look at this other motion. And this was filed by Brian Steele. This was the other one that Judge Whitaker addressed this morning. So for those of y'all who are just joining us, this was one of the motions that Judge Whitaker ruled on first thing this morning. So this is a motion in limine number 66. Comes now Jeffrey Williams by and through undersigned counsel and hereby files this motion in limine number 66 in the above referenced case. In support of this motion, Mr. Williams shows as follows. First of all, shout out to Thugger Daily for posting this. And of course, we know Brian Steele has to put this in every one of his motions. Mr. Williams is innocent of all charges in the above referenced indictment. Do y'all agree with that? If you agree that Young Thug is innocent of all the indictments, and specifically the RICO indictment, type a 1 in the chat. If y'all think Young Thug is guilty, type a 2 in the chat. Let me know. You will not be shamed. You will not be shamed for having a difference of opinion here on this channel. So don't be afraid to type 2 if you think it's 2. The prosecution had on its short witness list the fact that they were going to call Mr. Lamar, aka Rich Homie Quan, as a witness at trial. The prosecution did not call Mr. Lamar as a witness, and tragically, on or about September 5th, Mr. Lamar passed away. Rest in peace to Rich Homie Quan. Mr. Williams was intending to call Mr. Lamar as a witness at trial, however, now cannot do the same. Mr. Williams respectfully asks this honorable court to order the prosecution to not argue or ask at any time that Mr. Williams had the opportunity to call Mr. Lamar as a witness, as same is not true. Further, the prosecution failed to call Mr. Lamar as a witness when presenting their specious theory that Mr. Williams and Mr. Lamar were on bad terms since the fall of 2014, through the year 2015 and beyond. Mr. Williams intends to show the jury that the prosecution sent confirmations in writing that Mr. Lamar would be a witness in the case, but the prosecution never called Mr. Lamar. Thereafter, Mr. Lamar, months later, unexpectedly and tragically passed. Wherefore, Mr. Williams respectfully requests a hearing on this motion and the conclusion of the same, asks the honorable court to grant the above requested relief. Now, Judge Whitaker did deny this one, but Brian Steele did make an interesting point and something I didn't think it would be a big deal as just a juror who's watching this. So I want to see what y'all think too. Grace is in the building. Good morning, Grace. Shout out to Grace. I hope you have a good day as well. And thank you for stopping by. Hopefully you're feeling better too. What else are y'all saying here? I see mostly 1s. Anybody who typed a 2, I would love to know why you think that Young Thug is guilty. Let me see. Ooh, okay. ABK No Hearts said 2, that you think Thug is guilty. Walter Waller says 2. Okay, let me know what y'all think in the chat of why it would be 2. Let me see what y'all are saying. Let me see. So we've got Skur. Is that how you say it? Skur Dibble says, I would also like to know if Thug had any knowledge of them committing crimes before he rented any of the cars. Yeah, but that still wouldn't be in furtherance of, good morning, our hearts with arts, in furtherance of YSL, right? Even if he knew that they were criminals. It's not a crime to associate with the criminal. So even if he did know about the crimes, is he not allowed to rent them a car? I mean, I don't know. Unless they say, hey, Thug, we about to go, hey, nuts time is up, so I need you to rent me a car. It's not against the law. Also says if he knew they were still committing crimes, even if he wasn't benefiting off of them himself, then it's 2. Let's see. How the girl says Thug is guilty of allowing groupie criminals around him. Facts. But he wasn't their leader, dictating orders like El Chapo. I agree. Good morning to y'all. I agree 1000%. That's not, I meant to type good morning in the chat. I agree. And Scurry Dibble says that's not what I'm saying. So you're saying, let me read what you said. I would also like to know if Thug had any knowledge of them committing crimes before he rented any of the cars. If he knew they were still committing crimes, even if he wasn't benefiting off of them, then it's a 2. I disagree, Skr, because if I know you sell drugs and I rent a car for you and you go out and sell drugs, that's not a crime in itself. Right? But if you say if I rent a car for you, or if you come to me and you say, hey, can you rent me a car so I can sell drugs? And then I rent the car for you, then that would be a crime. So you would have to prove that Thug knew or was aware that these guys were planning on or trying to do something to harm Big Nut. And I don't see that. I haven't seen that in the state's case. And how could you put that on YSL when they're a record label? Yeah. No, you're good, Scar. We're just having a conversation. You're fine. You're fine. And also, how was that in furtherance of YSL too? Even so. Songbirdies McNair says he's innocent until proven guilty, and at this point, they have only proved he is guilty of making bad friends choices, which unfortunately, Songbirdie McNair, you know this, that can be making bad friend choices in some senses. I mean, it could be a crime. But it's not a crime in itself, but it could be at some point. I mean, I know someone who drove a getaway car not even knowing they were doing it, and they got decades in prison. You gotta watch, you gotta be careful who you're around. What else? Walter Waller says state has not proved RICO. I agree. But why'd you type 2, Walter? I want to know what your reason for typing 2 was. Who else is in here? Amy said, how can he be responsible for happenings he didn't know about until after they happened? A mob boss makes the calls and shots. The crew can't move until the boss says so. The state hasn't proved any of that. And even so, like even in a mob, right? Guys have their designated roles and they have the green light on certain things. So the mob boss may be like, hey, whatever y'all got to do, just do it. But that's in furtherance of the gang. Young Thug's not even saying YSL was a gang. It was a record label. He was doing his thing. He had guys in there that were recording music, some guys that were around that did bad things, but he wasn't like, hey, do what you got to do to further the mob. No, they were just doing what they were doing, and Thug was out here just trying to have a record label. So they got to prove that it was a gang first. I'm not even seeing that. Mark says, to date, the state has not shown that Sir Thug is benefiting from any crimes. No. And Amy says, yep, according to Love, he's worse than the mob. Oh my God. Well, we don't listen to Miss Love anymore. She's not even sitting in the chair. Nomads in here said, I've said it once, I'll say it again. They have a cork board, plenty of pictures, but the red string is either on the floor or 2 rooms down the hall. They still got it wrapped up. It's still wrapped up in the drawer. They haven't even pulled the red string out yet. Rice Street says, Thug ain't a felon, so he can hang with everyone. Interesting. Let's see. What else are y'all saying in here? Cookie Cooks says, imagine owning a business and renting a car from one of your employees or business associates. They commit a crime and you get blamed for it. Yeah, and that's just one. I mean, that's one instance. Again, I don't see any other instances other than Thug renting the car where Thug was even involved. I mean, think about that. Besides saying, this is the thing. Besides saying, oh yeah, I had issues with Lil Wayne and we weren't cool, and then his bus gets shot up, or his bus got shot up, then you said that. And that was really the only instance where Young Thug was involved at all. The other stuff, like Rich Homie Quan's barbershop being shot up, or his dad's barbershop being shot up, he wasn't involved. Car windows getting shot up, he wasn't involved. Woody snatching Nuts chain, Thug wasn't involved in that. I mean, where is Young Thug in this? I don't know. I'm missing it. Landon's Mobile says YSL had a clothing line too. Yes, unusual for a gang. That's a good point. Oh man, that's a good point. Did El Chapo have merch? I don't know. Y'all gotta let me know in the chat if El Chapo was doing his thing in 2024. You think he would have merch out here? Oh gosh. Yeah, the car was riddled with one bullet. Amy says the only thing Young Thug is guilty of is being in the wrong place at the wrong time and having friends who took advantage of his generosity and made bad choices. I agree 1000%. Sean says, first off, you don't rent nobody ish with expectations of them doing dirt with your name on it. Yeah, man, he rented a car for Lil Woody and Woody straight up said, oh yeah, it was Thug. Nasty work. And maybe, you know what, we should, if they're still out of court, we'll go and review that video that Lil Woody dropped. So thank you for saying that, Sean. We gotta go check out what Lil Woody's talking about. And Skur says it seemed like it was not one instance during Love's direct, but she was being so secretive of where she was going, she lost everyone. Oh wow. That's tough. I got this guy knocking on my door. I don't know what he's doing. Oh, okay, we're good. Dr. Stephen H is in here, says this case has exposed the shenanigans of the judicial system in Georgia. Fulton County is a whole mess. I agree 1000%. Phenomenal RN says some New York gangs got a RICO and they had a label too. Unfortunately, they do go after label gang hybrids. Yeah, but in most of those cases, Phenomenal RN, it's because there was organized crime, right? I mean, let's be real. But Young Thug, it's not the case. I'm not seeing it. Or I should say, I won't say it's not the case. I'll say the state hasn't proven that yet. Miji said El Chapo merch can currently be found on Amazon. Y'all go get y'all some El Chapo merch. Okay, so let me double check one more time to see if the state's back yet. They're not back in court. So what I'm going to do, we're going to take a quick break. And speaking of Lil Woody, we are going to cover his interview that he did recently. I think that'll be interesting to look at. And then I'll read some more of y'all's comments. Give me 1 second. I will be right back. All right, y'all. So it looks like they're still not back. Judge Whitaker is about to call this a day, I can guarantee you, but we'll go ahead and review this video from Lil Woody. I'm gonna find it real quick for you, and then we'll keep going. Let me read some more of these comments too and see what y'all are saying. Let's see. Shout out to Richie Rich in here, says Love and Willis thought this was going to be a kangaroo court trial, but they brought in real lawyers and weren't ready. Thought they was getting the practice squad, but they got the all-star team instead. Yeah, they majorly underestimated this defense team. And you know what though? Richie Rich, I think, and shout out to the defense for asking some great questions and doing a good job standing up for their client. But let's be real. The defense really hasn't had to do that much in this trial so far, in my opinion. I mean, Lil Woody basically ruined everything they had wanted to do with their star witness because he got up there and he didn't give them what they wanted. Judge Glanville had an ex parte meeting, got kicked off the entire trial. We've got Miss Love as up there, cannot get one of her witnesses to abide by the plea deal that they signed. I mean, the state has just done a really, really bad job. So we haven't really gotten to see the defense do their thing because they're just sitting back there like, y'all see this? Judge, this is not how you're supposed to run court. They haven't even started their engines yet. They're still sitting at the starting line, just watching Miss Love and Miss Hilton and the judge, I mean, ruin their own case. So I don't know, man. They look like the all-star team because the state is beating themselves up. So, and this is not to take away from the amazing attorneys on the defense side, but I don't know. I mean, what have we really seen from them other than some objections and some nice motions? Because the state is just killing this case. Shout out to Shadow Fox in the building. Dropped a 5-bomb, said the state was hoping Young Thug and YSL are like King Von and O Block. Yeah. No. Not even close, man. Not even close. Skur says that is a bad understatement. Yeah. I mean, I don't know. I could be on the defense side and I could write one motion. I'd probably look like a superstar right now because the state is just shooting themselves in the foot. Okay, shout out to Amy. She said they're coming back after lunch. Yeah, I guess I should have been checking X to see what Thugger Daily was talking about. Thank you, Amy, for that. So if they're coming back after lunch, then we didn't get much coverage in today. We won't be able to do after lunch. So what I'll do is, let's see. Let me see if I can find this interview and how long it is. Ooh, that interview is 50 minutes. I might save that for a slower day. So I wanted to do this interview with Lil Woody, but I think we're gonna save it for right now, and I'm gonna let y'all take a early lunch. But we'll be back tomorrow. Also, if y'all want to check out some music from some of the amazing independent artists in this community, we will be live tonight, 8 p.m. Eastern Standard Time for the Song of the Night Live. I host a show where a bunch of independent artists come together. They get a chance to win some cash, get their music heard, and gain some fans. And also, even if you're not an artist, you can stop by the show because we do give away a door prize where you have a chance to win $100 as well. So if that's something y'all enjoy, tune into the show tonight. Otherwise, like the video on your way out and be back here tomorrow at 9:30 a.m. Eastern Standard Time for another episode of the Music Morning Show. I appreciate y'all. Thank y'all for the love. Shout out to everybody who supports the channel, and I will see y'all tomorrow. You know what to do. Keep growing, keep pushing, keep it classy. We gone. Peace.